All right, good afternoon and welcome to 2021 FCA Year in Review and Emerging Trends for 2022. I'm Matt Feinberg. I'm a partner at PilieroMazza and I'm joined today by Jackie Unger, also a partner at PilieroMazza. We're here to talk a little bit about the FCA, hopefully give you some insights on what happened last year and what's coming for this year, and to answer any questions you may have about emerging trends in the FCA. And when we say FCA, some of you already know we're talking about the False Claims Act. So without further ado, let's get started. First, as I mentioned, my name is Matt Feinberg. I'm part of our False Claims Act and Audits and Investigations team here at PilieroMazza. Typically, I get involved once a company has encountered an FCA issue, whether that be a request for information from the government or as far as litigation has begun. I'm joined today by Jackie Unger, and I'll give her a chance to introduce herself.
Thanks, Matt. Good afternoon, everyone. I'm glad to be joining Matt on this webinar today. As Matt mentioned, I'm a partner in our government contracts group, where our practice runs the gamut of helping government contractors navigate doing business with the federal, state, and local governments. I'm also a member of our FCA Audits and Investigations group, and in addition to helping clients who face government investigations, I also counsel clients on FAR and SBA regulatory compliance issues, and I also represent clients in bid and size protests, as well as government and teaming partner disputes, as well as a variety of other areas. Back to you, Matt.
Great. Now, sure. If you've sat through one of our webinars before, you already know the general disclaimer I'm about to give. But today, this webinar is for informational purposes only. We are not creating an attorney-client relationship by providing this webinar, and we don't want you to rely specifically on the things that we might talk about here today because they're merely examples. If you have a specific FCA matter that you have questions about, we encourage you to reach out to us so that we can evaluate your specific circumstances and give you the appropriate advice for your specific situation. On the screen, a little bit more about PilieroMazza, the practice areas that we work in, the types of work we do. Jackie gave a little bit of an explanation of our GovCon group. Our litigation group does not only FCA work, but a lot litigation helping government contractors, whether that be labor and employment, contracts disputes, or other typical GovCon disputes. So happy to answer any questions about the FCA or the firm's capabilities. If you want to reach out to us, we'll have our contact information available at the end of the webinar. So let's get started with the reason everybody is here today. Our ultimate overview for the webinar is on the screen. We're going to talk a little bit very briefly about what the False Claims Act is. We're going to talk about what we saw in fiscal year 2021, including the government's recent release of its statistics for the fiscal year 2021, which ended at the end of September, including the types of recoveries that were received by the government, the types of cases that the government focused on. And then we're going to merge into some emerging trends and what we should expect for fiscal year 2022. We're already almost halfway into the year, but there's some interesting insights and announcements the government has made about its FCA practice moving forward. And then finally, we're going to wrap things up with a little bit about how you can protect your company, not only from these emerging trends impacting you, but from the FCA generally, because the FCA is one of the biggest risks that a government contractor faces. We'll give you some insights and some ideas for how you can help protect your company. So first, what is the False Claims Act? If you're on this webinar, you probably have at least a general idea of what the False Claims Act is. It was ultimately originally created during the Civil War, and it continues to serve to this day as the primary vehicle for the government to collect money obtained through misrepresentation or to retrieve money improperly withheld from the government. And the example that I give every time I have a webinar is that the False Claims Act exists based on the sale of decrepit horses and faulty gunpowder in the Civil War. the government determined that allowing unscrupulous contractors to provide the government with faulty or dangerous products was something that needed to be remedied, and so they created the False Claims Act. Although we're not worrying about decrepit horses anymore, the government focuses on what amounts to be a false claim. And a claim is a request for money or property to the government, or that the government ultimately makes to a business entity or an individual. A false, for purposes of the False Claims Act, means that the claim to entitlement to money or the claim to withholding money from the government was improper, incorrect, unlawful, unjustified, or supported by a misrepresentation. When I say false, though, not all incorrect claims result in a False Claims Act violation. It requires actual knowledge, deliberate ignorance, or reckless disregard. Those are the actionable intent levels that a person has to have in order to violate the False Claims Act. And the False Claims Act has both a civil and a criminal component, although you see the criminal side a little less often. For particularly egregious violations, you can see a criminal charge against a company or an individual who's involved. Typically, what you'll see is a civil claim, either a qui tam action or a suit directly by the government to recover not only the damages that are recovered, but statutory penalties as well. And we're going to talk about all of this very briefly as a primer for the statistics, but just giving you a little bit of the lay of the land. So there are two primary types of FCA matters, and all of this is important to understanding the statistics we'll give you a little bit later. First, there's a government-initiated matter, typically arising out of an audit or an investigation, or maybe even a whistleblower hotline to an Office of Inspector General or the Department of Justice. You'll typically see this in the where you will receive a subpoena or a civil investigative demand from a government agency. If it proceeds to litigation, the United States will be the plaintiff and will be pursuing a False Claims Act violation and damages against an individual or a company. There's also a private litigation right for individual whistleblowers, and whether that whistleblower is an individual former employee or a competitor or someone with insider knowledge, they can file what's called a qui tam matter. Essentially what they do is they file a lawsuit under seal, so the defendant or the subject of the investigation will not know about it right away. An investigation will ensue, and eventually the case will be unsealed, and litigation could commence 2 to 3 to several even additional years after that. But once those types of matters have passed their initiation stage, they proceed in roughly the same way with a standard litigation, motions practice, and discovery. For purposes of the FCA, there are certain common types of FCA violations. The first is a straightforward false claim or false presentment matter, and that means that a defendant submitted a false invoice or false request for payment to the government, requesting that it receive money to which it was not entitled. The second type of claim is a false record or false statement claim that usually involves a certification to the government, either a certification that's required by a government contract or a certification in, for instance, the system for award management about size or status or socioeconomic set-aside contracts. You'd also have implied certifications, which are not expressly made part of a contract or not expressly required of a company, but they are implied by the fact that you are a government contractor. These types of implied certifications can be that the defendant is in full compliance with the law, or that they're in compliance with cybersecurity requirements, for instance. A reverse false claim is a third type. That is where the defendant or the subject of the FCA investigation is already in possession of some amount of money or property that the government is entitled to. A really recent example of this would be when a company receives forgiveness of a PPP loan under the CARES Act when it was not entitled to forgiveness. That could result in a reverse false claims action. And then the fourth most common FCA violation is a conspiracy. You might see this where a subcontractor is submitting false invoices to a prime contractor, with the prime contractor then submitting the false invoice to the government for payment. You may also have a conspiracy between owners of a company who are trying to represent the company as falsely qualified for a set-aside program. Conspiracy generally requires a meeting of the minds, an agreement between two or more people to violate the False Claims Act. A little bit about FCA penalties. There is a mandatory damages component, which means that there are, let's say the case goes all the way to a jury, and the jury determines that there were damages in the amount of, say, $1 million for an FCA violation, the government or the court rather, is required to treble that amount. And that is determined in reference to the type of claim pursued. So the judgment that would be entered is a minimum of $3 million if the jury comes back with damages of $1 million. In addition, there are penalties that are imposed on False Claims Act violations, and that is anywhere from approximately $11,800 to approximately $23,600 per violation. And when we say per violation, that includes the submission of each individual invoice or certification to the government for a contract. So if you're submitting multiple invoices per month on a 5-year contract, you could have and over the course of the life of the contract, you've made a False Claims Act violation on all of those invoices, you could end up with a multiplier of, say, 60 or more per violation. It adds up very, very quickly. The statute of limitations for FCA claims, they have a very long shelf life. A claim may be brought by a relator, who's the whistleblower that brings a qui tam action, or the government, within 6 years from the time the fraud was committed, or 3 years from the time the government official charged with investigating the fraud knew or should have known about the fraud, but never longer than 10 years. This is why it's so important to keep documentation for years on end related to a government contract, because, like we said, a very long shelf life for these types of claims.
Okay, I'm going to jump in and talk a little bit about the annual False Claims Act statistics that DOJ puts out toward the beginning of every year. So we've just recently gotten the statistics for fiscal year 2021. And the overall takeaway is that DOJ's total monetary recoveries was a little over $5.6 billion. Which is a huge increase over the previous year, FY 2020, where the recovery was $2.2 billion. This is not quite as big of a difference as it might look because of a single settlement related to the opioid crisis that I'll get to in a couple minutes, which was close to $3 billion in and of itself. So when you take that away, the difference is quite not as large between the 2 years, but it is a very large recovery that DOJ has had last year. So, and this is the second largest annual total in False Claims Act history, and the largest since 2014. So breaking that total down a little bit, between the government-initiated matters and the qui tam-initiated matters. The majority of that $4 billion came from the government-initiated matters, which again is much larger than 2020, but largely because of the opioid settlement that the government recovered from. And for key TAM, they recovered $1.6 billion, which is a little bit lower than the $1.7 billion that was recovered in the prior year. And out of that key TAM initiated amount, DOJ also reported the amount that went to relators, which was $237 million in 2021 versus $324 million in 2020. So that's the total dollar value of the recoveries. DOJ also reported on the total matters that were initiated over the course of the year. And that's the total number initiated is 801, which is actually a little bit lower than the prior year. The government initiated matters is 203 versus 598 key TAM initiated matters. The government initiated matters is down 28% from FY 2020, but it's still the second highest total since 1995. So even though we see that that looks like a pretty big decrease, if you look prior to 2020, then it's actually still a pretty high amount that the government is initiating on its own, doing its own investigations and starting these and getting these recoveries from. So that decrease is definitely not enough to take away from that there's an overall downward trend, because it's still much higher than it has been over prior years. And then the key TAM initiated matters at 598, again, there's a bit of a decrease there. It's the lowest annual total since 2010. But while it's a decrease, it still amounts to an average of over 11 new cases every week. So there's still a lot of key TAM initiated matters going on there.
Before we go to the next slide, I do want to let you all know that Jackie and I drafted a blog on the annual statistics, gave some of our insights and discussion of the trends, basically the precursor to this webinar. It's available on the PilieroMazza website. So if you haven't gotten a chance to check that out, you should jump in there, because we have some interesting things, I think at least, some interesting things to say.
So some high-level takeaways from the numbers that we see. We see this rise in the government-initiated matters, as I was speaking about, compared to pre-2020. And the decrease in the key TAM initiated matters indicates that the government is likely relying more on its own audits and investigations that it's undertaking, rather than relying on whistleblowers and leading to the investigations and litigations. This is probably also likely to the government's increased use of data analytics to identify fraudulent schemes, which it has spoken to a number of times about trying to use more data analytics and do more data mining on the data that it has at its disposal to see how it can identify fraud. It tends to be used more in the Medicare scheme, in the health industry, where there's a lot of data to dig through there than necessarily other areas of like procurement fraud necessarily. But the government has stated a number of times that it is trying to see how it can use data analytics to help with FCA investigations and litigation. And so that could be part of the reason why we see, that could be paying off somewhat with this rise in the government initiated matters as opposed to the reliance on whistleblowers. And so even though we do see a little bit of decreases in the numbers that I was just talking about, we don't necessarily expect that to continue a downward trend. We would overall expect there to be increased matters, and in DOJ's recovery, they've made clear that pursuing False Claims Act investigations is a high priority for the government, and we don't expect that to change anytime soon. So as a result of that, it's super important for contractors to take subpoenas, civil investigative demands, requests for information, and any other inquiries from the government, including offices of inspectors general, very seriously, and to increase their compliance efforts and their internal audit procedures, making sure that those are in place and ready to go, and making sure that, even with those procedures in place, make sure that you're not ignoring any employee complaints, notices, reports of any kind, whether you think they're frivolous or not, because you don't know when those complaints might turn into a whistleblower. You want to make sure that you have an avenue for employees to make reports internally, so that their first step isn't to go to the government instead of working in-house.
And I'm going to go back to slide 11 really quickly, because something Jackie said sparked this one in my head. I think it's important for us to explain what it means when a total matter is initiated, or what that goes into that number. So there were 801 total matters initiated in fiscal year 21. What that means is the first step in an investigation was taken. That either means that a key TAM litigation was filed, but it is still under seal, or the first complaint came in from, say, a whistleblower on the hotline directly to an office of Inspector General. It takes years to get from total matter initiation to resolution. So when we look at numbers like 5.6 billion in total recoveries, or even 4 billion or 1.6 billion in government initiated or key TAM initiated matters respectively, that doesn't track to that 801 number. It tracks to a number that may be 3, 4, or 5 years ago. So the fact that we're seeing these total matter initiations, particularly on the government side, now means that in 4 or 5 years, we're going to see significant increases in the amount of recoveries from government-initiated matters that correlate with this emerging trend. So I thought it would be important just to make that clarification, so that it doesn't appear that 801 initial matter or matter initiations resulted in 5.6 billion in recoveries on such a short timeline.
Thanks, Matt. Okay, so DOJ also puts out statistics on a couple industries, and no surprise, the healthcare industry is where the largest recoveries come from. We see this year after year. The total recoveries in fiscal year 2021 were $5 billion, which equates to about 89% of the total recoveries. And the total new matters that were initiated were 485, which amounts to about 61% of the total new matters. And DOJ focused on a few different areas where the main matters are initiated. The primary one, what I spoke to before, relates to combating the opioid epidemic. The largest False Claims Act settlements in the past year resulted from significant resolutions with prescription opioid manufacturers, which I'm sure most of you have heard about to some extent in the news. DOJ highlighted its global resolution of criminal and civil liability against Purdue, which included an unsecured bankruptcy claim for $2.8 billion to resolve civil allegations that the company promoted its opioid drug to providers it knew were prescribing the opioids for uses that were not medically necessary and that were unsafe and often led to abuse. So, again, that makes up a huge portion of those overall, the 5.6 billion in recoveries, just from that one settlement. DOJ also highlighted the Medicare Advantage program. They noted an increase of investigations in litigation related to this program. Under Medicare Part C, the government pays a capitated amount to health insurers for each patient enrolled in the program, rather than paying for distinct patient services, and an adjustive payments for various risk factors, so that plans are paid more for enrollees who pose a greater risk. And so DOJ has recovered tens of millions of dollars in pursuing plans and providers that manipulated that risk adjustment process to make it look like their patients appear sicker than they actually were, so that they can get higher payments. So that's one area that DOJ has focused on and been able to get recoveries from. Another area is kickbacks. As we see every year, as DOJ reports on every year, the resolution of kickback allegations makes up a good chunk of the healthcare recoveries. For example, this included payment of over $400 million by generic pharmaceutical manufacturers to resolve allegations that they paid and received amounts prohibited by the anti-kickback statute through arrangements on price, supply, and allocation of customers with other manufacturers as part of a conspiracy to fix the price of certain generic drugs. So that's another area of DOJ's focus, as well as unnecessary medical services. DOJ reported that there were a number of recoveries that were based on allegations that providers were billing the government for medically unnecessary services, or services that they were billing for that were not actually being rendered. In addition, DOJ provided some stats on recoveries related to Department of Defense. It's a much smaller amount, but given DOD's large budget, it's an area that DOJ does break out the numbers for. The total recoveries there were $120 million, or about 2% of total recoveries, and the total new matters were 52, which is about 6% of the total new matters. So key takeaways here are that companies working in the healthcare industry must be hyper-vigilant given the significant annual FCA enforcement. It's always going to be a top priority for DOJ, focusing on the healthcare industry. And companies operating in the defense industry must be cognizant of increased scrutiny by DOJ and inspectors general as well. So again, recommendations here are to implement compliance programs and audit procedures, make sure that those are in place and that they're being followed, that employees are trained on them and aware of what those procedures are, and ensure strict compliance with cybersecurity requirements, which we've seen those requirements increasing recently over the years, and I'll touch on that a little bit later as well. So next, I wanted to touch on procurement fraud. DOJ doesn't publish annual statistics on procurement fraud matters and recoveries, but it does give some description of some of the settlements that it's had in the procurement fraud arena. And we've seen that there are a number of large settlements for various types of fraudulent conduct. So I wanted to touch on just the main areas that DOJ highlighted. One was related to falsified pricing data. These types of settlements include allegations that the contractors submitted false cost and pricing data to justify the reasonableness of their prices, such as like fraudulent commercial invoices that they would provide as backup for the prices that they've been charging in the commercial sphere that were not actually the true prices that they were charging in the commercial world. There are also matters related to misrepresentations about commercial sales practices during contract negotiations, where the contractor is alleged to have submitted false information to GSA about their commercial sales practices, and that they failed to extend lower prices to government customers as they're required to do by the contract, where they're offering lower prices to commercial customers and they need to do the same to the government. And they're failing to do so, yet they're certifying that they're complying with the contract requirements, which would make those certifications false. DOJ also reported on resolutions related to contractors who are supplying non-compliant or substandard products and services. And there are a number of settlements related to those types of allegations where, again, it's not simply providing non-compliant services or products, but rather the certification, whether it's expressed or implied through the request for payment, that the contractor is in compliance with the requirement, that the product is meeting all of the standards that are provided in the contract, yet that's not actually the case. That turns it into that false claim. And then, finally, DOJ highlighted kickbacks as an area in the procurement fraud field where they had a lot of resolutions as well. DOJ pursued allegations against prime contractors that accepted kickbacks from subcontractors in return for favorable treatment for those subcontractors. So important to pay attention to that relationship with your teaming partners and make sure everything is above board there.
So I've given Jackie most of the difficult slides which have all the data, but I want to talk a little bit about something that Jackie and I saw anecdotally through our practice over fiscal year 21. And that was an increased and particularized focus by the Department of Justice on small business procurement fraud. And there are a few ways that this has come into play. In particular, we've seen the DOJ focus on certifications by small business contractors about size and socioeconomic status certifications and their eligibility for receiving set-aside contracts and task orders. And there are some very important compliance issues that we will talk about a little later in this webinar, but we have seen a significant increase in the attention that is paid to whether contractors are actually small for the NAICS code that they're bidding under at the time of the submission of a proposal, whether they are actually owned and controlled in accordance with SBA regulations by, for instance, a service-disabled veteran or woman, depending on what their certification is. We've also seen a huge increase in attention on the mentor-protege program and joint ventures in general. Is the mentor taking control of the mentor-protege joint venture in order to gain access to contracts that otherwise would not be eligible for? And ultimately, that's what DOJ has been paying attention to the most with regard to procurement fraud over the last year or so, is whether there are large businesses or other than small businesses that are gaining access to set-aside program contracts for which they would not otherwise be eligible. Another primary focus of the government of late is the limitations on subcontracting and performance of work requirements for specific contracts. That is, again, an avenue where the government believes that larger businesses can take too much control over a contract that was ultimately awarded to a small business. And then this is particularly the case with regards to construction contracts. And so we've seen a huge uptick in DOJ investigations of the construction industry, particularly construction contracts awarded to small businesses or businesses operating in the set-aside, SBA set-aside programs. Also, it goes without saying that based on a number of Inspector General reports, that the CARES Act and COVID-19 pandemic were primary focuses of the government's fraud efforts in fiscal 21, and it's going to continue for a couple of years. Since the start of the pandemic, DOJ has worked with Inspector Generals and agency stakeholders to identify, monitor, and investigate the misuse of pandemic relief funds. I have seen a number of articles in particular over the last, about 2 weeks that have identified a specific attorney that is doing public record research to notify the government of companies that are receiving multiple PPP loans, improper PPP loans or idle loans. And so it's not just that the government is looking, is that the public is looking as well, trying to cash in a bit on fraud in the CARES Act programs. We have seen so far a number of settlements that I would describe as low-hanging fruit. For instance, the CARES Act and the PPP loan program imposed very specific requirements. For instance, you could not receive 2 PPP loans except under very specific limited circumstances. You were not allowed to receive a PPP loan if you were in bankruptcy. Those are 2 pretty clear examples where there's an objective answer. Did you obtain 2 PPP loans or not? DOJ has settled a lot of those claims. Ultimately, what happens is that there is, you are not entitled to forgiveness. the underlying PPP loan must be repaid, and then there's an additional penalty on top of that. So that's what we've seen so far. But what we've also seen is a significant increase in the number of audits of PPP loan applications and EIDL loan applications over the last 6 months. Although those haven't turned into reportable False Claims Act recoveries that would be in the DOJ report from September 2021, which is the end of the government's fiscal year, I expect we're going to start seeing more complex fights over PPP loans, whether companies were actually eligible for the loan at the time of the application, whether companies received forgiveness of loans when they weren't entitled to it. So we should expect to see a significant increase in CARES Act-related fraud investigations and resolutions over the course of the next 2 years. In addition, as I mentioned, there's one very specific lawyer who's looking into things, but he's certainly not the only one. We expect that there are a lot of QTAM actions that have been filed related to the PPP loan program and the EIDL loan program that are currently pending in district courts but have not yet been unsealed. That may mean that companies are getting civil investigative demands or subpoenas related to their PPP loans. All the more reason to take the subpoenas or CIDs that you receive very, very seriously, because ultimately there could be a litigation pending somewhere, and you want to make sure that you have the documentation to show that you were entitled to that PPP loan at the time both of applying for the loan itself and applying for forgiveness. So our ultimate recommendation with regard to COVID-related fraud is make sure that your compliance programs are in place and working as they should. You want to make sure that any federal dollars that you received through the CARES Act are being spent for the reasons they were distributed, and that contractors meeting the size and status requirements for obtaining the loan in the first place. For instance, if you weren't eligible for that PPP loan at the outset, you need to make sure that you're not seeking forgiveness if the forgiveness application hasn't already been submitted, because those are particularly difficult FCA claims to navigate as they become more prevalent.
Okay, so what else happened in 2021? I'm going to talk a little bit about these things. The Civil Cyber Fraud Initiative, DOJ announced the creation of this. The DOJ announced the rescission of the brand memo. They stated that they're going to be taking a tougher approach to white-collar crime. And we've seen in the Senate some proposed amendments to the False Claims Act. So I'm going to touch on each of these a little bit. Matt, can we go to the next slide? Thanks.
Sorry.
So first up, no worries. Next up, the Civil Cyber Fraud Initiative. Last October, DOJ announced a new civil cyber fraud initiative to combine the department's expertise in civil fraud enforcement, government procurement, and cybersecurity to combat new and emerging cyber threats to the security of sensitive information and critical systems. DOJ is planning to pursue misrepresentations by companies in connection with the government's acquisition of IT software, cloud-based storage, and related services designed to protect highly sensitive government information from cybersecurity threats and compromises. And the intent here is to use the False Claims Act to combat cyber threats. The DOJ has used the False Claims Act to pursue alleged noncompliance with cybersecurity regulations in the past, but this underscores there will be even more of a concerted effort to prioritize this type of fraud, identifying this type of fraud moving forward. The intent really is to enforce current cybersecurity requirements and new cybersecurity requirements that come out and deter noncompliance. But the creation of this initiative, the initiative itself is not making new requirements that contractors need to comply with. And it's not geared towards pursuing litigation based on the cyber breaches themselves. but it's more about when the contractor is non-compliant with its reporting obligations, or if its security program is just, a terrible mess and the contractor hasn't even attempted to comply with the security program requirements that it might be obligated to comply with in its contract. Those are really the situations that this initiative is going to be more focused on investigating. And of course, the risk is particularly high in light of the ever-increasing cybersecurity obligations that we're seeing be placed on contractors, such as DoD's Cybersecurity Maturity Model Certification Program. In addition, in May of 2021, President Biden issued an executive order on improving the nation's cybersecurity, which is aimed at strengthening the government's ability to respond to and prevent cybersecurity threats, including by enhancing the government's software supply chain security and implementing enhanced cybersecurity practices and procedures in the government. So with all of this focus on cybersecurity requirements and increased liability from non-compliance with those requirements, contractors need to make sure that they're aware of what requirements they are subject to, including cyber incident reporting requirements that may apply to their contracts. And if you're not clear, don't just ignore those obligations. Seek out counsel to help explain what those requirements are. And it's not enough just to figure out what the obligations are. You need to make sure that you're critically examining your existing systems to ensure that you're actually meeting those obligations, making good faith effort to be in compliance with those obligations. And then, of course, contractors should set up internal controls and reporting systems so that they're able to identify issues that need to be addressed and to, again, reduce the risk of whistleblowers going straight to DOJ, which happens when they may not feel that they are being heard within the company because there's not a good enough mechanism for internal reporting.
So before we jump to the next slide, Jackie, you made a really good point. These, although specifically the Civil Cyber Fraud Initiative is a new program that has been announced, it isn't imposing a very different requirement on contractors. For the last probably 10 years or so, the industry insiders have been wondering when the first FCA cases related to cybersecurity were going to come out. And they started to trickle in a couple of years ago, first with cases related to the contractor's failure to comply with express cybersecurity requirements in a contract. And then a little bit later with a settlement, about almost $10 million settlement on a company's failure to comply both with its own cybersecurity requirements and by its failure to allow the government to comply with the government's cybersecurity requirements. So there's two aspects of cybersecurity that you have to be very cognizant of when you're performing a federal contract. Obviously, there are cybersecurity requirements factored into your own contract with the government or maybe your subcontract with a prime contractor. Those seem pretty obvious. They may even be express certifications you're required to make as part of your invoicing. But the second set of cybersecurity requirements is an implied certification. In other words, the government would not have awarded a contract to the prime contractor or the prime team if the prime team was incapable or was not ensuring that the government could comply with its cybersecurity requirements as well. And so there's an implied certification that not only is the cybersecurity requirements of the underlying contract being performed, but the contract is being performed in a way that allows the government to meet its obligations as well. So those are the cases that have come out recently. There's been a bit of a pause in cybersecurity announcements on FCA violations. They just haven't come up quite as much, probably with the transition to CMMC. but we will expect to see an increased number over the next few years as the transition to CMMC becomes more real for contractors.
Next, thanks, Matt. Next, I want to talk about the DOJ's rescission of the brand memo. This all relates to how an agency's non-binding guidance documents will be used for purposes of an FCA investigation or litigation. So a little bit of history. Before 2017, DOJ often relied on these sorts of non-binding agency guidance documents that relate to agency procedures or interpretation of regulations or statutory requirements to help establish that the defendant submitted false claims and that it did so knowingly, because this guidance is out here and the defendant's actions were not in accordance with the sub-regulatory guidance that exists. So in 2017 and 2018, DOJ issued a couple of memoranda, the second of which is referred to the 2018 memo as the brand memo, which explicitly limited this practice. And in addition, in 2019, President Trump issued an executive order requiring that agencies treat guidance documents as non-binding. It provided that guidance documents cannot create binding requirements that do not already exist by statute or regulation, and that non-compliance with guidance documents could not serve as a basis for proving violations of law. So that was more protective of government contractors who may not be aware of the guidance documents or not in compliance with the guidance documents, or where they have a reasonable interpretation of a regulation, a regulatory requirement or a statutory requirement that conflicts with the interpretation that the agency has put out in its guidance documents. So those memos were more protective of government contractors and limited DOJ's ability to rely on those sorts of guidance documents to prove a false claim or that the government contractor submitted the false claim knowingly. So President Biden rescinded Trump's executive order his first day in office, and in July of 2021, Attorney General Merrick Garland issued a memo rescinding the brand memo. So that now permits that Garland's memo still recognizes that as a matter of law, agency guidance documents are non-binding, yet it still permits DOJ to rely on agency guidance documents in any appropriate and lawful circumstances, including when a guidance document may be entitled to deference or otherwise carry persuasive weight with respect to the meaning of the applicable legal requirements. So DOJ could try to argue that even if a statute or a regulation is ambiguous, that a claim is knowingly false if the agency interpreted the statute or regulation in a way that would prohibit the defendant's conduct, and that interpretation is entitled to deference. So as we see through changes in administration, sometimes there are differences in how litigation will be pursued. So this is an interesting one where there's been this back and forth on the reliance of these guidance documents, and now makes it a little bit harder again on government contractors to, even though they are not subject as a matter of law to requirements that may be stated in the guidance documents, particularly where they are not elsewhere provided in statute or regulation, those guidance documents can be relied on to understand what the agency's interpretation of these statutory and regulatory requirements are.
Great. Before we jump to the next slide, we've gotten a couple of requests about whether the slides will be made available. We typically don't send them out to all of the webinar participants, but the webinar will be available for replay on PilieroMazza's YouTube channel. And if you'd like a copy of the slides, feel free to reach out directly to me or to Jackie, and we'd be happy to get you a copy of them.
Okay, so the next issue deals with DOJ's tougher approach to white-collar crime. In October of 2021, DOJ announced some steps that it's going to take to enhance corporate criminal enforcement. The first of those relates to restoring the Yates memo from 2015, which relates to cooperation credit for corporations. So to be eligible for cooperation credit and leniency, companies must provide DOJ with all non-privileged information about individuals involved in or responsible for misconduct at issue. This is a change from what had been the prior approach under the Trump administration, where it would be sufficient for companies to limit disclosure to those they assess to be substantially involved in the misconduct. And so companies wouldn't necessarily, to be seen as cooperating with DOJ, they wouldn't necessarily have to turn over all information about everyone potentially involved in the misconduct that had been identified by DOJ. They would only have to turn over information related to those substantially involved. And now DOJ is saying, nope, if you want to get cooperation credit, you've got to give us all the information you have that's non-privileged about everybody who's been involved with the misconduct at issue. Another change is that all prior misconduct by the company will be evaluated in making decisions on a resolution rather than just misconduct that's similar to conduct at issue in the investigation. So DOJ is signaling that they are going to look at the company as a whole, whether it may have had violations or gotten in trouble in any other areas, not just the specific issue that has been investigated by DOJ at that time in determining what the resolution is going to be. And then finally, DOJ has also rescinded its 2018 DOJ guidance that discouraged the use of independent monitors. Independent monitors can be set up when there's a non-prosecution agreement or a deferred prosecution agreement to an external monitor outside of the company to make sure that after there's a resolution with DOJ, to make sure that the company is in compliance with whatever reporting or compliance obligations are in those agreements. And there had been prior guidance that seemed to discourage the use of those monitors. Now DOJ is saying that the DOJ attorney should feel free, the prosecutor should feel free to require the imposition of independent monitors whenever it is appropriate to do so in order to satisfy the DOJ that a company is living up to those compliance and disclosure obligations under those deferred prosecution agreements and non-prosecution agreements. And then finally, the last area relates to proposed amendments to the False Claims Act. In July 2021, a bipartisan group of senators led by Chuck Grassley introduced the False Claims Amendment Act of 2021. Two primary areas of the amendment. The first relates to Escobar's holding on materiality. And the amendment specifically states that the government's decision to forego a refund or pay a claim despite the government's knowledge of fraud is not dispositive of a lack of materiality if other reasons exist for the government's decision. After Escobar came out from the Supreme Court in 2016 related to materiality, a lot of defendants would try to file motions to dismiss and were successful filing motions to dismiss, saying that the government continued paying my claims and allowing performance on the contract, even though they were aware of the fraud. Or the alleged false claims. So those false claims can't have been material to the government's decision to pay. And so therefore materiality can't be established. And they were successful with a number of those motions to dismiss. So this amendment is now saying that continuation of payment in and of itself is not sufficient to show that the false claim is not material to the government. So it makes the burden a little bit harder now on a defendant and it makes it more of a question of fact that would maybe need to go to a jury rather. then be able to deal with it at a motion to dismiss stage. Much more fact-driven, and it's favorable to the government as well. Also, the amendments would provide for DOJ to dismiss a qui tam case. It sets a more specific standard in that situation. It would require DOJ to identify a valid government purpose and a rational relation between the dismissal and accomplishment of the purpose. And once that's shown, then the burden would shift to the relator to demonstrate that the reason for dismissal is fraudulent, arbitrary, and capricious, or illegal. And so this legislation made it out of the Senate, the Judiciary Committee in the Senate in October of 2021. Sometimes we see amendments get floated and nothing comes of it, so we'll have to wait to see whether, these amendments actually make it into law or not.
Thanks, Jackie. So let's talk a little bit about the trends for 2022. And Jackie has touched on these a bit over the course of the slides she's been talking about. But despite a drop from fiscal year 20, new qui tam and government-initiated matters are expected to increase for all of the reasons we've discussed. There is a particular focus on procurement fraud and small business fraud. There's going to be a push for CARES Act investigations and fraud resolutions as well. Typically, when the country is in crisis, False Claims Act investigations and claims increase. And if typically it's related to times of war, financial crisis such as the mortgage loan crisis, and of course COVID-19. So we expect those numbers to go up. We also expect for there to be an increased DOJ reliance on government investigations and less on whistleblowers. That doesn't mean that whistleblowers are going away. They're certainly going to continue to file qui tam actions. There is a significant incentive for whistleblowers to file qui tam actions. But as Jackie mentioned, data analytics has made it easier for the government to identify areas of potential fraud, and that gives them a leg up on whistleblowers who don't have access to the same kinds of data. The primary focus for Fca Matters moving forward is going to continue to be healthcare, because Medicare and Medicaid are particularly susceptible to fraud. We don't anticipate there being a significant change moving forward. However, we do expect the numbers to come closer to evening out in the future, as they have historically been about 65 to 70% over the course of the last 10 years or so. In 2021, due to the opioid resolutions, it was more like 90%. We expect it to go back to about 65%, still going to be the primary focus. And as I mentioned, increased DOJ focus on small business set-asides and mentor-protege fraud, cyber fraud, and COVID-19 fraud. So very quickly, we'll give it a couple minutes. We're going to speed through these last slides. How to protect yourself from Fca liability. One of the most important things you can do is know your contract obligations and your obligations as a contractor in general in advance before you find yourself in the midst of an Fca investigation. Know what the law is and what your contracts require, and make sure you have internal audit procedures and standing operating procedures that will allow you to ensure your compliance. You also want to assign specific duties to an employee or set of employees, such as the person who's responsible for determining whether you are small for your NAICS codes, or whether you're in full compliance with the obligations of a set-aside program to ensure that, say, your operating agreement has the service disabled veteran and have it with ownership and control. And make sure that you have internal checklists or forms to fill out to make sure that you're following contract compliance requirements and ensuring that you are compliant with your set-aside certifications. With regard to training, you want to train your managers so that they know what the Fca is, where the pitfalls are, and how they can resolve any problems that they see on the front end before it becomes a bigger problem for the company. With regard to whistleblowers, you absolutely have to take employee complaints seriously. You need to investigate them, make sure you have a paper trail and a contingency plan for how you handle those types of complaints when they come in. It's very easy for you to say, this person is a problem employee, they're constantly complaining, it's too hot, it's too cold, I don't have fast internet, and they might make themselves the boy who cried wolf. But ultimately, if the wolf shows up in one of their complaints, then you would be ignoring a potential opportunity to cure a problem before it turns into an investigation. You want to make sure that even when an employee identifies themselves as someone who's going to be complaining on a regular basis, that if they make complaints that could impact FCA liability, that you're taking them very seriously and investigating them to the fullest extent. So what do you do when you discover a past or current FCA violation? Jackie talked about this a little bit. You want to make sure that you make a mandatory disclosure of the violation to the government so that you can cure the problem and limit the amount of damages that you're going to face. You may ultimately be entitled to cooperation credits that will avoid substantial liability. If an FCA matter is filed against you, or if you receive a subpoena or a civil investigative demand from the government, you might receive a grand jury subpoena, a civil subpoena from an Office of Inspector General, or a civil investigative demand. Those documents will identify the False Claims Act in their preamble or their initial paragraph, so you'll know right away and what you need to be looking into. You may not know the specifics of the investigation, but you'll at least know that the False Claims Act is invoked, and you'll want to make sure that you have a lawyer look at that immediately and communicate with the government. You may also receive a search warrant. For more significant FCA violations, Department of Justice or the U.S. Marshals may show up on your doorstep with a warrant, and they may want to take computers or access witnesses. Don't panic in those situations, but do not talk to the government without counsel. If they have a search warrant, you want to ask to see it, and you want to make sure that your attorneys are involved as quickly as possible to handle whatever is coming your way. Also, you want to stop routine document and email destruction. The last thing you want in an FCA investigation is to have destroyed a document that could ultimately vindicate you, or destroy a document that might be bad for you because then the government thinks you are hiding evidence. You want to make sure you obtain knowledgeable counsel to assist you in the investigation and to act on your behalf. And you want to make sure that your attorney is initiating an internal investigation at your company to identify knowledgeable witnesses and make sure that the appropriate information is getting to the government so that you can cooperate in the investigation and limit your exposure. For that, you want to verify that you have a paper trail for the investigation, and you want to make sure that you're documenting the entire process from start to finish. So I've sped through those last 3 slides pretty quickly, the last 4 slides. The reason I did so is because we have a number of webinars in our history on that topic. You can access us on YouTube, on the PilieroMazza channel, or you can find links on Jackie and my profiles on the PilieroMazza website. I don't have any active questions that have been submitted, but if you have any, it would be good to get them in right now so we can address them. Otherwise, we've had a great time today. We hope you enjoyed our discussion on the False Claims Act annual statistics and where we're going for 2022. If you have additional questions or you're looking for legal advice, please don't hesitate to reach out to me or to Jackie. Our contacting information is on the screen right now. We will have a number of FCA. We hope you'll join us for those, and we hope to hear from you on other topics as you need help. So again, on behalf of myself and Jackie, thanks so much for joining us. We'll talk to you next time, and I hope you enjoyed the webinar.